Next, I'd like to welcome up Michigan Creditors Bars Association, Stuart Best, President of Michigan Creditors Bar Association, and stakeholders Weltman Weinberg and Rice Co. Opposed to bills. Welcome.
Good afternoon. Thank you. Thank you for the opportunity. I've got a statement. I'd like to jump on a few things very quickly before I jump into the statement. First of all, the young lady that just spoke, there is many options for her available to assist, and some of those I'd like to highlight today during my presentation. So if you listen to it from that respect, these are the items that are currently in place that can help people. We are, as the Michigan Creditors Bar, trying to push these items to make sure that these folks are aware of, and these items are made more available to them by the use of the court systems and by legislation to foster these ideas so that it's better for them versus this bill. Well, good afternoon. My name is Stuart Best. I'm the president of the Michigan Creditors Bar Association. I'm a practicing attorney and a partner in the law firm of Weltman, Weinberg, and Reese, one of the largest collection firms in the United States. I am a native Michigander, and I work in the Troy office of our firm. Michigan is unique in its collection process, and it provides many opportunities for borrowers to make good on their promises. To give you a short explanation of the collections process, under federal law, upon receipt of the file, our first communication to the borrower we're required to send is a notice. It's called the model validation notice. This notice gives the opportunity of the debtor to understand their debt and also to object or agree to the debt. They can also contest the debt by checking a box, very simplistic form. It also requests them to contact our office, and you'll hear a theme throughout this entire discussion that communication is key here, and this is what we want to foster. Communication with the debtor between the law firm and or the company trying to collect is extremely important. This also requests that this is the first contact from our office, yet there's been numerous contacts by our clients. They make regular contacts in written form, phone, other attempts to contact the debtors to make sure that they can discuss a potential repayment of the debt. Anytime at each step in the process, a payment plan is offered or other settlement options are offered, either a reduction in the total debt, but basically we're trying to get a payment that can be afforded by that debtor as well as satisfy the debt. Because if not, it creates what we call the death spiral, where they get debt they are not paying off and it just makes it worse. It's accruing interest and it's not moving things forward. What's not widely understood about this process, in the collection process, even being an attorney, is that litigation is really our last step. We're really trying to negotiate and work with these debtors to see, in fact, if we can get them to pay and get on a payment plan, again, that's affordable for all. Basically, once after that model validation notice is sent, we then send a follow-up letter. We're attempting to contact the debtor during this process to discuss again, let's talk a payment plan, let's put you with a collector, let's talk with someone and work through this. Only after our client has contacted them on a regular basis, we have contacted this debtor on a regular basis. At that point is only when we go to the last step in this process, which is then filing a lawsuit. Once the filing of the lawsuit, they are served. Once they are served, they have 28 days to respond. In the event they respond to the court, which, by the way, in all the courts now, the SCAO has forms out where they can literally check boxes and submit that to the court as an answer or response. The courts then force us to work with these debtors on numerous occasions. They look at pretrial conferences, we attempt to talk it out. They put us in Zoom conferences on a regular basis or put the matter through facilitation or mediation in an attempt to work out the debt and get this payment paid. If you can understand here, this is a very long and tedious process, which is not delayed, but it's made in a system that allows that debtor the opportunities in which to do something here, work with us. It's only after we have talked with the courts, we've tried these attempts to talk to them, that we then go in and attain a judgment of default if they fail to respond to the court, or for that matter, a judgment by providing the proofs into the court. A default, by the way, is not simply we don't have to provide our proofs, we actually have to provide proofs of the debt under federal and state law, and then the court orders the amount that's owed. After that happens, then the debtor at any time in this process following that judgment entry has the opportunity, which you've heard passively here, but I'm going to lay it out for you. It's called a motion for installment payments. It's very simplistic. The borrower says, look, I can't afford to pay this debt. It's so many thousands of dollars, but I can afford to pay this amount. The court then reviews the amount of the payment. The court reviews their income, their expenses, and says, all right, we're going to set it in a specific amount. The court says to the debtor, make this regular payment. This is a last resort after everything is done, but this is an opportunity that is only available to Michigan residents and a few other states. It is not talked about because it is a very important process that needs to be talked about. The Michigan Creditors Bar Association has been looking, and we'd like the courts to require that that option be presented to the debtor. That they affirmatively stated. If we stated it looks like they're trying to do something nefarious. If we set that up so that the court system says, by the way, file this motion, the court will then look at these items. This judgment law as it's written, and Senator Irwin and I have been, and as well as all of us have been on numerous calls, we have been discussing this, yet the numbers, especially in the amended bill, are too high. This sets a class of debtors that are flatly non-collectible. If there's no end for these debtors, where in essence we can't collect, we can't work with them in making a payment plan and are garnishing wages by her comment of 50% of her paycheck, this is not true. The maximum we can currently get is 25%, and there's also, if a garnishment is filed, they have the opportunity to object to that garnishment. They can say, look, this is too much out of my paycheck, can you please reduce it? It works just like a motion for installment payments. Again, another opportunity that we would love the debtors to go to. We don't want to collect them if they can't afford the debt. We do not want to take their car if they can't get to work. We don't want to have them kicked out of an apartment. That is not the intent. The intent here is to get them on a track where they can pay. And with setting a bar so high as far as a garnishment, it will not only, which others will talk about, decrease the availability of credit for this exact group that can't afford, that needs this assistance, it's going to also kill their availability of credit. It's very simple when you look at a bank and a financial institution, right? They lend on one basic premise. The premise is they're going to get paid back. They need to get that money back to work and to operate. If, in fact, that availability for them to get those funds back is not there, that is inherently going to cause a reduction in the availability of credit. The Act also does take some shots at some things that we think are very important and need to stay in place. Michigan also has the Michigan Judgment Lien Act. Understand this is a system where if I take a judgment against a debtor and they owe us money, if they have real property within the state, we can, by the way, in most states it's automatic, but we can record that judgment against real property. We cannot foreclose on that. This is not a judgment lien that can be foreclosed. It simply sits on the property, and when the debtor is able to pay, either voluntarily, pays the debt off, completely will release it, or the property is sold or refinanced, they come back to us and we negotiate and or they pay us off. It gives us some protection. That protection using that Judgment Lien Act releases the banks, gives them a little bit more room for credit because they've got the ability to collect. It is, again, not something that's foreclosed. It simply placed the lien out there. If, in fact, the property is foreclosed, that is removed. If it's tax foreclosed, it's removed, it's gone. But that judgment lien is out there for a protection for the bank, but it also assists in them making and paying their debt.
Apologies. I don't want to cut you off because I do want to extend. I think this is a very important topic for and opposed testimony, but I do want to try to stick to about 10 minutes, just as for conscious of time for members as well, because we do have committee afterwards. So if you can wrap up a couple sentences so we can have opportunity for questions.
I will do so. Thank you.
Thank you.
Basically, the problems with this law as written. Okay, number one, it's going to tighten credit availability. We know that it's a simple economic fact. Second of all, if it doesn't decrease that, it will clearly increase the cost. So therefore, interest rates will go up. That's the last thing we need right now is higher interest rates that are going to be charged. It'll also force the lenders to stop lending to those individuals that they can't collect from, i.e. under this act, if you're making $70,000 or less, we can't garnish against you that you are non-collectible. Why would we lend? Why would a lender lend to that group? So it's inherent when you look at the availability of credit, it's going to drop. This also puts this debtor in what, again, I'll repeat it again, a death spiral where they are not paying off their debt. It's sitting out there. We're not assisting them in any way by providing this, Senator Irwin's even wording, a backstop. This backstop is an artificial backstop. It doesn't assist them in making these payments. Pugh's comment a moment ago stated that this act is going to allow them to pay their debts. It does just the opposite. It creates a hard line where we cannot collect. There is no back for them. They can sit tight and not pay debts and incur additional debt potentially and have this still hanging over their heads. This is not just about the numbers. We've talked about the numbers extensively, but also there's other nuances. I'm finishing. Sorry. There are other nuances in the bill that cause us many, many other issues that we've talked about, and the fact that the amended bill was dropped on us on Friday. We have seen those amendments. Some of those actually make portions of this bill even worse for us. I apologize for maybe running over my time. I'm available for any questions if you have any today, if not also in the future.
No need. I appreciate your testimony and appreciate you wrapping up so quickly. Senator Irwin.
Thank you, Mr. Baston. We've been having lots of conversations and sharing lots of paperwork about these changes for several months now. I appreciate all of your time and attention to it, genuinely. But it feels like we've been going back and forth around this, orbiting around this one claim, in, which you said is sort of a basic economic fact that I think to a certain extent we can all agree that additional risk changes the calculation for lenders. I'm not quibbling with that point. But one of the things we've been really struggling to find is to find evidence of that effect anywhere in the actual world in which we exist. Mm-hmm. So if Michigan residents have less protections than people in any other state around us and have vastly less protections in states like Texas or South Carolina or Florida, can you show me how Michigan residents are materially benefiting with lower interest rates or greater access to capital? Because I have not seen that. I have not seen the evidence of the claims that you're making. Can you point me to them?
Yeah, as far as specific dollars, I'm not a numbers person, but we are a national law firm. And I will tell you that across the United States, what will happen on the national lenders, and I'm not talking about debt buyers, which everybody concerns themselves with. We'll talk about straight-up credit card companies. Across the board, they're going to increase the rates. They're not going to specifically nail them Michigan to other states. They're going to increase them across the board. The banks and community banks will be testifying to that in a few moments. We've got the community bankers on that side. I'm on the collection side, not as much on the economic side. But I will tell you that from a credit reporting standpoint, as Patricia started to allude to, that if you have an agreement to pay, your credit report is going to be different than a debt or a charged off debt. It's going to be paid as agreed, settled, or in settlement, or in payments. There's many different definitions that will give them more availability to credit versus a charged off debt, which is a huge ding on your credit report.
Yeah, thank you for the answer. I just want to highlight the very beginning of that answer, which I found to be actually very alarming. Because what you said, in effect, was that, well, no, if we increase protections for Michigan residents facing debt collection, you're not going to see the impact of that here. You'll just see it felt nationally. The implication of that is that Michigan residents are currently paying with higher interest rates and less access to credit for the protections that people in other states enjoy. So why wouldn't we bring our protections for Michigan residents up to something near a national average so that our residents aren't financing the risk that residents in other states are bringing to the financial institutions' tables?
Well, I disagree. That's from a national standpoint. But from the local standpoint, the credit unions and the banks, of the credit unions in the state, which are going to testify today, understand that that $70,000 limit we talked about, anything under that is not garnishable. You can't garnish someone that's making 70 grand. If you talk to the credit unions, their average depositor is maybe 80,000. That they make $80,000 a year or $70,000 a year. That income level is going to eliminate most of the ability for those community banks and credit unions to garnish you wages, which is completely a disparate impact on those credit unions and banks, the ones that provide most of the financing for these exact people you're trying to protect. These are the folks that we work with. The credit unions and community banks and the banks in the state of Michigan that want to provide this financing. You put this in front of them and say, look, you can't garnish someone that makes under $70,000 a year. Why would they lend to them? They can't afford it. Nationally, those larger companies can assume and push that debt across the United States. Michigan bankers can't. They have to deal and address with this right here. And if they can't collect that debt from the Michigan members and or depositors, then they're going to have to stop lending to that. And I'm not here to testify on the economics of that side of it, but to give you the idea that in Michigan, we have other available remedies, and I think that we could work better. And Senator, when you and I talked about this a little bit, we can work in a different fashion to provide through the legislature a better process to assist the debtors on a point-by-point basis. By using a broad brush, you are also protecting not only those folks that can't afford this, but you're protecting the ones that have the ability to pay and are hiding behind the act. And that's the biggest fear of us. We're not here to collect against some 80-year-old lady on Social Security. That's not what we're looking at. I'm looking at somebody that is higher, that is an income level, that has money, that under your statute is actually allowing them to make investments and not pay their debt, diverting income as well from the payment of debt. They should be assisting getting their credit in line versus putting money away and saving money. They should be using that to, in essence, to protect themselves and get their credit in line. It works in opposite of what we're trying to do.
Thank you. Senator Tice.
Thank you. If you could just real quickly summarize. So from the point that someone has a credit card, they don't make a payment on the credit card, what's the time frame on the process till it gets to you, till it gets to court, and till it gets to garnishment?
Okay, so typically a lender will have that debt held in-house for 30, 60, or 90, maybe upwards of 120 days from delinquency. That's a typical window. We will then get it usually at 90 to the 120 mark if it's a lender that wants to move fairly quickly. So you figure that during that period, that's post-default. That's post all of their notices. Once we see the file, we actually do not proceed on collections. We provide that model validation notice, so let's call that day one of receipt. We can't move forward for 30 days, and typically it's 45 days before we can take any additional action. After that 45, throw another 30 on that because we tend to send out another collection letter saying, hey, talk to us. So another 30 on top of that. Once that happens, then if we do have to file suit, we file suit and it takes us usually a week to 2 weeks to get it into court, but then the debtor has, after they are served, which is an issue, finding the debtor. Once we find that debtor, they have another 28 days, really 30 days in which to respond to the complaint. The court won't look at that file typically for at least a couple of months thereafter, at which point they will call a pretrial, we'll have hearings, we will have what's called a motion for summary disposition. Once that occurs, so you're talking adding another 3 months on roughly. Once we get to judgment, then they have 21 days thereafter before we can even start collection activity. So minimally a year would be a good rough figure that during that period we're negotiating or trying to communicate with them to try to get a payment plan in place. Once that judgment's in place, then we can file a garnishment if in fact we know where they're employed and if we can locate a bank account. So a year plus 30. So it's not a immediate walk in the door and by the way tomorrow you're going to get sued and get garnished. That's just not even a reality in my world. At the fastest, if we have a court that's even moving quicker than that, we're still talking a minimum of 6 months before I'm going to even see judgment at best.
Thank you. Senator Bayer.
Thank you, Madam Chair. Thanks for your testimony. I keep looking at the numbers in the data, and it looks like, first of all, 70,000 is way, way higher than at least the current version of the bill is. But it looks like, and I appreciate you're trying to protect our banking industry, which is important to us. Most of these debt collections are companies like yours, national companies, and most of the time, people don't even know that they have some kind of issue, and they don't hear about it. They don't have the funds to get a lawyer. Mm-hmm. I mean, you're really going after kind of the people who are like the one who spoke earlier, really too poor, right? She's working 3 jobs. She doesn't really have time to chase after this. If she even maybe lives I don't know where she lives, but people lose their housing, right? They're in a circumstance where it's very difficult for them to be a part of a long-standing set of communications between someone from another state they don't even know about what's going on. So it just feels sort of, tacky.
Well, let me bounce that back for 1 second. First of all, I say we're a national firm. I'm located right here in Michigan, and we do all of our work for Michigan right here. And most, I would say, even though we're probably the largest collection firm in Michigan, probably 50% or better is not national companies. They are the community bankers. They are the credit unions and those institutions. We do file a lot for the credit card companies from a volume standpoint. I completely disagree when people say, look, I never knew this was coming. The number of notices that have been sent out by the clients, the number of notices and the service of process that is done in the state of Michigan, unlike some states, we actually require a process server, or we have alternate service as well, but a process server goes out and serves them. So they know this debt is coming down. And there are people that may not ever look at their mail and or understand the process. I give you that. There is a percentage of people that it's inevitable that, are not going to understand or know about the process. Majority of the people that we deal with do know about the process, and we're confirmed that they do get sued, and they are being sued. Another factor that I heard earlier, that the issue of some of the paperwork that was out there that I thought was very interesting, to your point, is we would prefer, in fact, that if the debtor obtained a counsel. The number of what's that?
We're talking about people who are very poor. They cannot afford it.
Absolutely.
So would you live on $20,000 and have time from your 3 jobs to deal with this? They don't know how to do it. It's just you're going after the most vulnerable part of the population here, and they don't have self-defense.
The problem with this bill, though, is it's such a wide brush that it's protecting those others that do need and can afford to pay their debt, but they're not. So as far as the free legal services that are available, we would love to see that expanded. If organizations like Pew and others would put it into a free legal service and expand that process, that would be amazing for us. I would much rather deal with an attorney that understands their client and work with them than dealing with a debtor that doesn't understand. I'm trying to explain the process. I make the comment that we want the Michigan legislature to force the courts to offer the payment plan system, because I cannot go to a debtor and say, by the way, file this motion. That's the illegal practice of law. That's also in violation of my ethics. I can't go to the other side and tell them how to practice, but I would love to. So in the event that we can provide them better services, I think we're better off.
Thank you. I do think we have an additional question, but I just want to provide an additional comment just about that. I've heard a lot in just a lot of these negotiations and a lot of these bills is that we don't do this all the time. We just need it. And so I hear a lot of a scare tactic for people, and that's the only way we can get them paid. In history of any constituent that I went through that had to go through this process, being scared does not open mail, pay bills, and I understand there are good actors and bad actors. I just want to be cautious of how we have these conversations about what we need to have in order to pin it up against someone that's in not the best time of their lives. So I do want to open up space and last comments before we have to move on. Senator Irwin.
Yeah, thank you, Madam Chair. I wouldn't dream of asking Mr. Best another question, but I did want to just point out that in the sub that we adopted before we started the debate, the threshold that we set for protection of people's wages is not at $70,000. It's at $26,000. So that's the kind of wage level we're talking about. 50 hours at minimum wage in a week equals $26,000, I think.
But not in the calculations we've done. I apologize, but the calculations we've done and looked at, it does actually hit a $70,000 number with the first exemptions at 35, the 15% increase that was put in the last bill as well. And again, so we disagree on the income level completely.
Thank you. I appreciate your testimony and the questions
from
committee members. Next, I'd like to welcome up Deshaun Ashby, Director of State Advocacy at Michigan Creditors Union League. We heard a little bit about you during earlier testimony, with Angela Kimbrough, Director of Payment Solutions from One Detroit Credit Union, opposed as written, and I hope I pronounced your last name correctly.
Kimbrough.
Oh, Kimbrough. Thank you.
Definitely different from the House version. Thank you so much, Madam Chair. Vice Chair, members of the committee. My name is Deshaun Ashby, and I represent the Michigan Credit Union League. We are a trade organization that represents 184 credit unions across the state of Michigan, comprising of over 6 million Michigan residents. And this is my colleague, Angela Kimbrough, and I will keep my remarks very brief so that the subject matter expert can kind of talk about some of the work that she does and the things that she's seeing on the ground level. Before I begin my testimony, I first would like to say thank you, Madam Chair and Vice Chair, for hosting the work groups, being trusted partners in this situation. And as you said earlier, Senator Irwin, that this is a hearing. This is something that we're still working towards and still trying to find that common ground on. So thank you both, and thank you to your staffs for continuing to facilitate those, and we hope that that goes further. We are opposed as written. As you've heard, some of the thresholds are high for us, but I want to highlight why that is the case. It's not necessarily that we're saying you made the loan, you need to pay it back. It's more so that this does generate an access to capital issue for us. When we, as credit unions, we are small community-based lenders. Many of our credit unions are smaller in asset size, including one Detroit credit union here that is about 50 million in asset size. When we make loans to individuals, sometimes they are in situations where they probably can't get loans from elsewhere, where they probably can't get approved from elsewhere. It's not just about looking at your credit score and saying you're approved or denied. You know, we look at your credit score, we look at your payment history, we look at your relationship, and we try to find ways to where we can help those individuals in situations where they may need it the most. Additionally, when we do make those loans, as Angela here will talk about, we provide a number of resources for our members, whether it's counseling, letting them know that there are skip pay options, letting them know that there are installment payment options, making sure that they are adequately educated. There are a number of our members that even provide a certain level of insurance in the event that you may be laid off or you are out of work, that if you pay a little bit extra up front, you will not be charged those payments throughout the duration of those loans. So we try our best to make those considerations for our members. As I previously stated, many of our credit unions serve underserved communities, C, D, and E tier credits, including one Detroit credit union here, and that's not just our only one. We have about 34 CDFIs in addition to our credit unions that serve those communities of need. If we can't make these loans because we're injecting a lot of risk, one of two things will happen. The first thing that can happen is if we cannot accept that risk in the event that we cannot garnish if necessary, then we might end up having to raise the prices of some of the services that we hold dear, you know, increased interest rates or having more stringent standards when it comes to doing those loans. In the case of garnishment itself, that's not something that we want to do. No one actually wants to do that process. As you've heard from the testimony earlier, I mean, I think it's heartbreaking for many of us. But what garnishment is it's an insurance policy. It's a tool in the event that and it's a little bit different for us than it is with the creditors bar, where we make a loan and we try to get it back, or we'll communicate you, we'll try to have installment payments, we will try to do as much as we can to help you out in those situations. But if we can't make those loans, either the prices go up or credit unions like One Detroit go away. Yeah. They either go away, and then we are left with the vacuum of individuals that are underserved, and they are subject to financial institutions that are more susceptible to taking those risks. Senator Irwin, I know we talked yesterday about this as well, and I know that you brought it up again today. I did want to briefly touch on the subject of Texas because, yes, it is true that they do not garnish, but it's, as we heard from the previous testimony, garnishment is still a legal proceeding. It's still a judgment process. So even in that case, you know, your funds are still frozen and you still do have to go back and negotiate, which is something that we are also very familiar with as well. I spoke all the way around the corner. I want to conclude before I hand it over to Angela. We do understand that this statute is archaic and needs to be updated, which is why I'm glad that we've been continuing to have these conversations. And there are a number of protections that we would like to see, but we can't get there until we address the piece of the income threshold, which is why we're testifying in opposition today. In the case of the earned income tax credit, we are fully in favor of not garnishing that. We are fully in favor of finding avenues to put more money in Michiganders' pockets, especially at a time right now where inflation is extremely high. And even with our current statute, it doesn't adjust for inflation at all. So I would like to continue those conversations if possible, and thank you again so much. And I'm free to answer any questions before I yield the remainder of my time to Angela.
Well, I'd love for you to begin testimony, and then I'll open up to questions, but appreciate the ongoing conversation as we go through this process.
Thank you.
Thank you, Madam Chair, and thank everyone that's here that's provided me the opportunity to come. Okay. I am Angela Kimbrough from One Detroit Credit Union. We are a CDFI credit union. Our mission is solely to impact and change lives. About 60% of our members are underserved or in poverty level. So we experience members like Ms. Goolsby all the time. I talk to those members on a day-to-day basis. One thing I tell my team, I have a team of 3, I tell them you have to be able to empathize with our members. There's no judgment zone when we're talking to our members. Most of my team can relate to those members. I'm grateful to have the staff that I have because they are able to relate to those members. It's not where we're these hard collectors and we're just, we need a payment, we need a payment, we need a payment. One Detroit Credit Union is a very unique credit union. We offer loan products to members that simply other credit unions and or banks don't offer. We have members that we offer to refi their loans. Your interest rate could be 15, 20%. We're going to cut that loan rate in half. We offer products to graduates from college, from high school, first-time auto buyers. Those interest rates are low as 10%. We will not be able to offer those type of products to our members if this bill is currently passed in this current state. We just simply wouldn't be able to do it, where a lot of our members are told no somewhere else. They can come here to our credit union and we're giving them a chance. We're taking that additional risk. We do realize that members go through things, especially during the pandemic. It was really rough for the entire country. We served, we have about 12,000 members. During that time, we approved over 900 extensions, totaling over $8 million. So we are in the business to helping our members. As Deshaun has stated, we and others have stated, we do have things in place before it even gets to that collection process. We're calling, we're texting, we're emailing. So we're going through all of these methods before it gets to a judgment. We don't charge off a loan until approximately 180 days. So that shows you what type of effort that we go to before we even get to that charge-off state, before we even send it to our local attorneys. So we're doing everything that we can. Ms. Goolsby was a member of my credit union. I would have worked something out with her. Is it a workout loan? Possibly. Is it an extension? Possibly. Is it a skip pay? Possibly. So for her to go through what she's going through, we get it, we understand it. I'm not just collecting just to say, give me a check, give me your money so I can, or if you don't, I'm suing you. That's not the type of conversations that we're having. We need to try to recover those funds so we continue to have those special products to help those future members. We understand life happens. We currently have a member where I could have just sent her to our collection, to our attorneys. She has a terminal condition going on. She's not sure if she's going to live or not. I'm not going to sue her. I'm not going to enter a judgment against her. That's the last thing I want her to do, is to stress about a $3,000, $4,000 loan. Miss So-and-so, when you get back on your feet, call me. I'm sending you goodwill. I'm sending her goodwill cards. Just thinking about you. Hope everything is well. When that member got back on her feet, I think we were probably the first creditor that she called back. Thank you for even caring about me that way. I just got back out of remission. I'm back to work. What can we do? We worked out something for her. So that's what we're in the business of doing. Yes, we need to recoup the money that we lend out, but that's not our sole mission. We want to recoup those monies that we lived out so we continue to offer loan products that specialize for our members that's underserved and underbanked.
Thank you for your testimony. Any questions? Senator McCann.
What's the product that you mentioned that charges a 10% rate, please?
That's the first-time auto buyers program.
Thank you. Senator Bear.
I'm really in awe of your work, to be honest. So why do you think that it would be disastrous, is kind of what we're looking at for your work, if we have to do this. And yet our numbers are so much off from the states around us. If we really were to put it at a level as our neighboring states, we would be in a terrible condition, but they're okay? What do you think the difference is?
You want to go first?
Yes, thank you, Senator. Again, that is something that we've been very keen on and paying attention to. We do know that as far as the additional factors and protections and exemptions that are offered, Michigan is at the bottom of the barrel. Even if we look at a state like Ohio, who does do the 25 times the minimum wage and 25% income, which is very similar to Michigan, except it's 30 times the minimum wage and 25 times the income, the amount of money that they protect in home and auto and account is very different. So that is something that we are in full acknowledgement and in agreement of, and that's very similar to our other neighbors as Indiana. As I previously mentioned, the Credit Union League is still very open to having that conversation and that dialogue. But the reality of the situation is we had to address the proposed income thresholds first. And I would be remiss to forget that the sub makes a lot of progress and moves the needle from where the original bill was, from 80 times to 50 times. Even at 50 times, that ties us for about the third highest in the nation. So it feels as though, and this was mentioned earlier, we'll go from bottom of the barrel to nearly the top of the crop. And that is something that is, I feel, detrimental to where we're working with. And I will allow Angela to have any additional comments before you could follow on, Senator.
And just to give you a little bit of a perspective from One Detroit Credit Union's perspective, our average deposits for our member is $100. That's what they're really keeping in their account, is $100. So essentially, we wouldn't be able to have any, bank guards go there because they're not. Our members simply don't have it to save like that. We're really serving the underserved and the underbanked. So it would hinder us a lot if these bills are going through as it is right now. Me personally, as a collector, I want to make sure that I'm clear that we do want to work. I do recognize that the bills are ancient and there needs to be some change. But just for my credit union, speaking for One Detroit Credit Union, this bill could potentially put us out of business, and it could potentially affect other credit unions in the area. And what we don't want to happen to our members that are currently underserved and underbanked is going to the larger banks and getting charged the higher interest rate, or potentially steer them into payday lenders. We're trying to get them away from the payday lenders now, but I feel like this bill could potentially put them right back there, or they won't be able to get these car loans that they need to get back and forth to work in the city of Detroit. So just from One Detroit perspective, I think it's going to be very detrimental right now.
Just one quick comment on that, just because this is really, really important, I think. When we think about the reality of the numbers, right? So at $217, you're talking less than $12,000 a year in income. People can't live on that, right? I mean, it's just absurd to think that that's an okay thing and then to even raise it up to the current sub-proposed level of $26,000. I mean, how many people do you know who can live on $26,000 anymore? Right, you're just so poor. So anything extra, 25% over the top, anything out of that money. I remember the time when I was poor and I had $10 a week to spend. That was all the money that was more than my bills. And I lost my wallet one day and the whole $10 was in it. Yeah. I was crushed just by that one thing. So, I mean, you just get ripped apart. And then when you get a flat tire, you're done. So, I mean, we just have to keep the perspective, and I appreciate what you're doing, and I think it's great that we are going to work on this, but that's really poor, $26,000. We just got to find a way to do this. Sorry, thank you.
Yes, absolutely, Senator. And I want to mention a couple of the figures in there that spoke to us that we've talked about. For one, and again, the sub makes a lot of progress compared to the original version. In the original version, it was required to have about $15,000 in a bank account. In the sub, you changed it to $800. When we had that conversation, a lot of people do not have that. And the dialogue that we had is, you know what, that might pinch us a little bit, but it's something that we can work with. You talked about tools of the trade earlier, and you mentioned something that we at the Credit Union League have been talking about very seriously, in that you know, in this current climate, tools of the trade can mean so many different things. It can mean your phone. It can mean your laptop. Currently, it's exempt $5,000, $2,500. Like, yes, change that. We don't want to take away anyone's livelihood to work. The current exemption for a car is $1,500. Who can afford that nowadays? Plus, we don't want you driving a $1,500 car. We're trying to get those things off the street.
Right.
Exactly. We want you to be able to have the ability to go to work or to go pick up your children, things like that. So and again, the earned income tax credit, we want to protect that. We've had a conversation about how we can do that, and it does come down to a coding issue, and I know that the bill sponsors have been working to try to figure that out. So I totally hear your concern, Senator, and there is a lot of room, I believe, to get to where we need to get to.
Thank you. And I do want to move on, but I do want to reiterate just the great work that we have, not only just understanding where we're coming from, trying to change it from the archaic, but also where that sweet spot is. So I appreciate the feedback and ongoing work. And as chair of LEO, I understand CDFIs, and that is not the intent of the bill. And we really want to get to that sweet spot to make sure consumer protection and banks and credit unions that provide those wraparound services still can exist and thrive here in Michigan. So I appreciate that testimony. Last, that we'd like to welcome up